In today's lecture, we are going to discuss two important doctrines in Civil Procedure Code, namely doctrine of res judicata and doctrine of res sub judice. Section 11 of Civil Procedure Code embodies the doctrine of res judicata. In Hindu law, it is known as Purva Nyaya. Section 11 explains this doctrine with the help of 8 explanations attached thereto. Res means thing and judicata means adjudicated or decided, and therefore res judicata, this expression means the thing or the matter which is already decided. The doctrine of res judicata is applicable not only to suits but also to appeals, execution proceedings, writ petitions, special leave petitions, industrial adjudications, and even proceedings before the tribunals such as the Central Administrative Tribunal, Railway Tribunal, Income Tax Tribunal, and so on and so forth. Now let us come to objects of res judicata. The first object is no one shall be vexed twice for the same cause of action. Second object is it is in the interest of the state that there should be an end to litigation. And third object is judicial decision must be accepted as correct. If the doctrine of res judicata would not have been there, then we might have witnessed an explosion of litigation. So to keep the control on number of litigations also, the doctrine of res judicata is very important doctrine. In Supreme Court Employees Welfare Association versus Union of India, All India Reporter 1990 Supreme Court 334, it was stated that the principle of res judicata is intended to prevent a new investigation so that the same person cannot be harassed again and again in various proceedings upon the same question. Further, in Lalchan versus Radhakishan, All India Reporter 1977 Supreme Court, page number 789, Honorable Justice, as he then was, Y.V. Chandrachud, observed that the principle of res judicata is conceived in larger public interest that all litigations must sooner or later come to an end. So with that object in mind, this doctrine has been incorporated in CPC. Now let us come to conditions for application of res judicata. The first is former and subsequent suit. Second is the matter directly and substantially in issue must be same actually or constructively. Then third, parties in both the suits must be the same. Fourth condition is that parties must be litigating under the same title in both the suits. Fifth condition is that the court which decided the former suit must be competent. And the last and the sixth condition is that the matter directly and substantially in issue must have been heard and finally decided in former suit. So these are the 6 conditions for applicability of doctrine of res judicata as mentioned in section 11 of Civil Procedure Code. Now let us come to the first condition that there should be 2 suits, former and subsequent suit. So it is important to know what is meant by former suit. For the applicability of section 11, there must be 2 suits, former and subsequent suit. According to first explanation, former suit means previously decided suit, although in point of time it may have been instituted subsequently. For example, the first suit was instituted on 20th January 2005 and the subsequent suit was instituted on 15th April of 2007. But the suit of 2007 was decided on 10th of June 2012 when the suit of 2005 was still pending. Here the suit decided in 2012 is former suit, although it was instituted subsequently. So the expression former suit should be understood as the suit which was previously decided, although in point of time it may have been instituted subsequently. So that should be the meaning of the expression former suit. Then second condition we have seen is matter directly and substantially in issue. So what is the meaning of this expression? In state of Karnataka versus All India Manufacturing Association, All India Reporter 2006 Supreme Court, page number 1846, it was observed by the Supreme Court that on the basis of explanation 3 to section 11, it can be said that matter is directly and substantially in issue if it is alleged by one party and either denied or admitted by the other party. This principle was stated earlier in Devaram versus Ishwar Chand, All India Reporter 1996 Supreme Court, page number 378. Now to give the example, A sues B for rent due for the year 2018. B's defense is that no such rent is due. This is therefore a matter directly and substantially in issue, whether the rent for the year 2018 is due or not. So it will be the matter directly and substantially in issue. Now next condition is that the parties in both the suits shall be same. This principle is based on the logic that decrees and judgments bind only parties or privies. If former suit is decided between A and B and the suit property is subsequently purchased by C, then C will be called as a privy bound by the doctrine of res judicata. A person is a party to the suit if his name appears on the record of the suit at the time of decision in the suit. If a person withdraws or his name is struck off, or a person who is made a party either by fraud or without knowledge cannot be called as a party in true sense. If parties in both the suits are different, then obviously the doctrine of res judicata is not applicable. Now one more essential condition is that the parties in both the suits must be litigating under the same title. Then only the doctrine of res judicata will be applicable. For example, A filed former suit as eviction suit under the title landlord against B, who is a tenant. After dismissal of the said suit, A filed subsequent eviction suit as landlord against B as tenant. The subsequent suit will be barred by res judicata as parties are litigating under the same title. Then one more condition is that the court should be competent. For the application of doctrine of res judicata, it is necessary that the court which decided the former suit was court of competent jurisdiction. It means that if the former suit was decided by the court not competent to decide the same, then the doctrine has no application and subsequent suit will not be barred. So that is the meaning of competent court. Then former suit should have been finally decided. For applicability of doctrine of res judicata under section 11 of CPC, it is necessary that former suit should have been finally decided on merits of the case. It means that if the former suit was dismissed merely on technical ground, such as dismissal for default or non-payment of proper court fee, then the subsequent suit can be filed. Now let us come to some decisions. The first is Sulochana Amma versus Narayan Nair of 1994. It was held that res judicata applies to quasi-judicial proceedings before tribunals also. In another case, Govindaswamy versus Kasturi Ammal of 1998, it was held that res judicata is applicable to both plaintiff and defendant. Further, in Umayal Achi versus MPM Ramnath Chettiar, it was held that even if the previous suit is wrongly decided, the doctrine of res judicata will be applicable. Now let us come to the distinction between estoppel and res judicata. Estoppel flows from the act of parties, while res judicata flows from the decision of the court. Second distinction is that estoppel is a rule of evidence, while res judicata prevents an inquiry in limine. Third is that estoppel prevents a person from saying two opposite things, while res judicata forbids a person alleging same thing twice in the litigations. And the fourth point of distinction is that rule of estoppel precludes the party to deny what he or she once called truth, and res judicata presumes the truth of decision in the former suit. Then let us turn to constructive res judicata. If you read explanation which is attached to section 11, then we come to know that there is a concept known as constructive res judicata also. If the issues which might have been raised in former suit are not actually raised by the parties, then they are not allowed to institute subsequent suit by raising those issues, and it is called constructive res judicata. Similarly, the decree passed in a representative suit will be binding upon all on whose behalf such suit was instituted on the ground of constructive res judicata. Now, there are a number of cases on doctrine of constructive res judicata. In state of UP versus Nawab Hussain, M was a sub-inspector and was dismissed from service of DIG. He challenged the order of dismissal by filing a writ petition in the High Court, which was dismissed. He again filed a petition on the ground that he was appointed by the IGP and had no power to dismiss him. The Supreme Court held that the suit is barred by constructive res judicata as the plea was within the knowledge of the plaintiff M and he might have made this argument in the writ petition. Then in Anchal versus Krishna, AIR 1982, Allahabad High Court, page number 282, where liability of the insurance company is limited to policy amount, sued by insurance company filed to recover excess amount paid to the insured from the owner of the vehicle would not be barred by constructive res judicata. Now then let us come to representative suit. Order 1, Rule 8. There should be numerous persons. The parties should have same interest. Then permission should have been obtained from the court before filing such representative suit. And lastly, the notice issued to parties whom the suit is to represent. So if these conditions are fulfilled, then the suit may be instituted as a representative suit. And a decree passed in the representative suit will have application for all the persons who are represented, and doctrine of constructive res judicata will become applicable. Now examples of representative suit. Representative suit on behalf of all the creditors. Representative suit on behalf of all the taxpayers. And in TN Housing Board versus TN Ganpati, the case decided in 1990, it was held that representative suit can be filed for flat allottees in lower income group. So these are some of the examples of representative suit. And lastly, we come to doctrine of res sub judice. This doctrine is given in section 10 of CPC. It is titled as stay of suits. According to this doctrine, if the suit between same parties litigating under the same title arising out of same cause of action is already pending or sub judice before the competent court, then the subsequent suit cannot be instituted in the same court. In res judicata, former suit should be previously decided, while in res sub judice, the former suit should be pending or sub judice. And these are the references you can look into for the doctrine of res judicata and res sub judice. So with this we come to the end of this particular lecture.